Hi everyone, Jack Meligan here, President of Settlement Professionals. I wanted to talk today about approved lists and why approved lists as promoted by casualty companies in the settlement of cases involving structured settlements are a very, very bad deal for the plaintiff and by extension the plaintiff attorney. The approved list means that the casualty company has an approved list of defense-oriented annuity brokers that they will work with and allow the plaintiff to work with. And then the second type of approved list is an annuity issuer approved list. In essence, it's the companies that the casualty company defendant will let the plaintiff pick from when it's time to pick a company to fund their annuity payments. So let me cover the first one. The approved list of brokers is bad because it sets up a situation where the defense broker has perhaps an exclusive arrangement, or to make the approved list with the casualty company, he's had to agree to help push that casualty company's agenda. What agenda is that? Well, casualty companies like to try to turn this into a profit center if they can. As a structured settlement works its way through a case, the casualty company would like to find some sort of way to benefit from that. How do they benefit? Well, it could be a direct kickback or rebate, which is legal in California and I think Florida, as long as the casualty or the defense broker is offering the same rebate to all of his clients. The other way that they can benefit is if they have an internal program that says we have a wholly owned affiliate, life insurance company, that issues annuities, and we want the claimant to place their structured settlement annuity with our wholly owned affiliate. Or a very limited list of other carriers. And I'll give you some examples in a second. But going back to the approved list of brokers, when a defense-oriented structured settlement broker has agreed to represent the casualty company's interests, then he's agreed to their agenda, whatever it may be. And if it includes a rebate or a kickback, whether disclosed or not, and many of you know that have worked with me know that I'm big on getting the defense brokers that I'm asked to work with in putting a structure together for a client. I'm big on getting those brokers to disclose to us whether there is a rebate or a kickback. Now, why do I think that's important? Because no one likes to have to give money away. And I don't think these defense brokers are any different than I am. They don't like the fact that they've got to give whatever percentage of the earnings off of the placement of the funding vehicles in one of these cases. They're not happy to give that money to a casualty company. So I think that it sets up a situation, potentially, for a defense broker to look for a way that he can get that rebate or kickback back to the client without it coming out of his commission. How can he do that? Well, they might be able to do it by creating a savings on the annuity through an interest rate arbitrage. In other words, committing the annuity with the personal injury claimant before they've actually locked in the price, and in the interim time that occurs between the date that the plaintiff agrees to a set of payments and the date that the settlement agreement is executed, then there might be interest rate changes that are interest rate improvements, which would lower the cost of the annuity, which means that instead of requesting $100 or $100,000 or $1 million to fund an annuity package, maybe the defense broker only needs to request $90,000 or $900,000 or $950,000. Those are probably extreme examples, but you get the picture. I'm maintaining that it's possible that the defense broker could point to that savings to the client and say, there's your rebate or kickback. And we maintain, SPI, that those types should, the tax code that creates this exemption for these payments doesn't mention casualty companies. It mentions us, taxpayers. When we get injured, we get an exemption from income for these payments. And I believe it rightfully so that it should benefit the injured party.